Good morning. Welcome to Member Focus Monday. I'm Christina Schaefer, Social Media Manager for HAR. I'm joined this morning by HAR's Legal Counsel, Grant Harpold. Grant, welcome.
Oh, thank you.
Thank you so
Great
much.
to be here.
Thank you so much for coming back. Before we get into all of the questions that I've prepared for you, I just want to mention that today's Member Focus Monday and the HAR On the Move podcast for this week are sponsored by Rodox, a telemedicine company you can trust. So we'll hear more about them a little bit later. But for now, Grant, again, thank you so much for joining us for the fifth time?
Oh, who keeps track?
I mean, I tried to, but I can't anymore.
All right.
But for those members who are tuning in and just meeting you for the very first time, if you don't mind, if you could introduce yourself.
Yeah, I'm Grant Harpold, legal counsel for HAR. I'm a licensed attorney. I've been practicing law in Texas since 1988. And predominantly doing a lot of work for you guys, basically, over the years. And so I'm here to help even more and keep helping and do my best to answer and provide information and have a good time this morning.
Very good. And how long have you been affiliated with HAR?
Oh, probably 7 years, I think.
7 years.
Yes.
Yeah.
My firm had a long time affiliation with them, and then I became more involved probably 7 years ago.
Oh, that's great.
Yeah.
Thank you so much. And if you have any questions as we're going through, just go ahead and type them in. I see a few people telling us good morning. Hi from the house company in Galveston. So
I know the house company,
yeah,
sure.
There you go.
Yeah.
All right, so let's get into it. Last time you came on, you let us know a little bit about the Nara Lawsuit. Can you give us an update on what's going on with that? Maybe first let's explain what it is, and then if you could give us a little update.
So there's a lawsuit filed nationwide that's pending in Chicago. It's a federal lawsuit, and the goal of the lawsuit is to seek a class action claim or lawsuit against NAR and some franchisors, national brokers, on the premise that the listing agent, through the cooperation rule of cooperating or sharing their commission with the buyer's broker, artificially inflated the cost of hiring that listing agent, overpaid or overcompensated commission-wise, and so somehow that was a violation of the law. And so that lawsuit is pending in Chicago, like I said, in federal court. There's NAR has filed a motion to dismiss, seeking to get rid of the lawsuit, and so far the court has not ruled on that. And so that's kind of where it is right now, is that the parties, the plaintiff and the defendants, NAR and some national franchisors, are waiting to have the court rule on that motion. If the motion is granted, then the case is dismissed. If it's not granted, then probably the next step is to see whether the claim is worthy of a class action certification. So it's a multi-tiered process.
Yeah, right.
And it's probably a process that will take some time.
So that was my next question. Do you think this is something that we will see settled soon?
I don't know about settlement. I think it's going to have to run some legal courses before it gets to the point of really discussing the case on the merits, as far as, pursuing it, litigating it, resolving it, stuff that typically happens once a case gets more further developed. And this case is not there at this point.
So do you have any advice for our members? Obviously this is something that's been in the news, and if it continues to, move along, I think it's going to be reported on even more. Do you have any advice for our members on maybe what to say to clients and customers that might ask about it?
Yeah, I think, it would be like if you personally were in a lawsuit, is that it's really up to the courts. You don't really have much control over it. And so, trust the system, let the courts, let the lawyers do their job, and see where it ends up. I mean, that's typically, litigation, whether it be this litigation or any litigation, you just kind of keep going about doing your business and just let the courts and the lawyers deal with that as it progresses.
Okay, very good. Thank you for that update. So something big came out of the last NAR conference called Mls Clear Cooperation. Can you clear that up for us a little bit? Maybe tell us what that is?
Who came up with that title? Whenever I see the title, I'm trying to make the connection with what the rule is. But anyway, yeah, so essentially, there currently, or there was a time when you could, when your client and you as a listing agent could decide not to have a property on the MLS. You can see in the listing agreement, could check the box, this property is not going in the MLS. And that was fine. And that can still be fine, but now with this new rule that is actually effective January 1 of this year, but won't become enforceable until May 1. And what the rule essentially says is that that's fine if you want the property off MLS, you can still do that. But essentially the moment you decide to start advertising that property to the public in any manner, then it has to go into the MLS, really one business day after you start that, quote, public advertising. So remember, kind of your mindset now is, hey, my client can choose to not have this property on the MLS, but I can still advertise it. I could still put it on the internet. I could still put a sign in the yard. I could still put it on Facebook, whatever.
Sure.
Which, what the rule does says, yes, you can still do that, but the moment or within one business day after you do that, you got to now put it in the MLS. So
Okay.
That's the rule.
And it sounds like the rule is applying to any advertisement outside of your brokerage. So if I were to call you and you are with a different broker, that is a form of advertising.
It's
that correct?
That's been a good question, and it appears to be that way. That if I have the listing off MLS and you as a broker or whoever not within my firm and not a client call me to ask about the property, what do you say? No, I don't know what you're calling about. Why are you calling me?
Plead the fifth.
If I answer this question, am I now public advertising?
Right.
I think NAR hasn't been real clear on that specific point, but the general feeling is that they would consider that public advertising.
Yeah.
Because if you're going to be off MLS, I mean, it's going to be, and this rule's always been there, Rule 1.3 in the MLS rules, office exclusive. If you're going to have that office exclusive, meaning you're not going to have it on the MLS, you can share it within the company or within the brokerage. You can share it with your clients, and that's kind of a loose term. But beyond that, if you do much more than that, it would be considered public advertising. Yeah.
Kat is asking, is this only applied to HAR members? This is a national.
Well, if you're a MLS member.
MLS.
Yes.
Okay. And to Kat's point, locally, because it sounds like every MLS can decide how they're going to comply with this rule. Do we have any ideas on how HAR is going to comply with this rule, or what the process is, what we're doing here locally?
Right, and the rule is the rule. I mean, you can look it up. You can Google NAR Clear Cooperation rule, and you can take you right to the lead article on the NAR's website. It explains it, and I have it printed right here, so it's even I can find it. So the rule's the rule, and that rule, as you see it right now written, will go into our MLS rules. Now, how we adapt that and maybe throw in some other bells and whistles and coming soon and stuff of that nature, that's being developed right now through committees, through a committee at HAR, and ultimately it will be something will be decided and implemented that allows the rule to be active and enforceable.
And I think it's important to note that those committees are comprised of HAR members, so they are other realtors, your peers.
Right, not me. I'm not on the committee.
Yes,
so it's
neither of us are on that committee.
purely fellow HAR members coming up with this, practitioners, people that are going to have to deal with this also, that are
they'll also have to comply with the rule.
Right.
Ram asked just to verify, so will this apply to anyone with a coming soon post on social media?
Yes, coming soon would be considered advertising, and so that component of all of this is part of what the committee's looking at. But yes, coming soon would be considered, if you post something about the property coming soon, that would be considered advertising, so it would have to be in the MLS at that point or one business day thereafter.
Okay, very good. So moving away from that subject, and if anyone else has any other questions about it, we can of course go back. Actually, I see one question that just came in before we move along. Mitch asked, if the homeowner starts advertising, how does this work, i.e. on Facebook, etc.?
That's a great question, and that's a tough predicament to be in, but I think under the NAR interpretation, that would still be considered public advertising.
Mm-hmm.
And so you would have to put it on the MLS within one business day after your seller may go do something, even if you didn't know it or bless it or sanction it. That's part of this whole process. If you go to, like I said, if you go Google it and pull it up on the NAR website, there's a bunch of FAQs,
Mm-hmm.
and they're somewhat helpful. So I mean, there's a lot of this is it's going to be trial and error, I think,
Right.
and I think at the end of the day, and maybe I'm wrong, but this should really only affect a small percentage
Small percent.
of the market, because I would think that for most properties, the ideal is to get it in front of as many eyes as possible. And the MLS is the best way to get it in front of as many eyes as possible. Maybe there's that high dollar property that's for a limited group of people could afford, and there's some real extreme privacy issues involved.
Mm-hmm.
Maybe that's the office exclusive model that fits, but I think for the broad market, it should be business as usual pretty much, or it
Yeah.
should be. So.
And I think this is something that maybe each brokerage might have to review once HAR's members decide on how we're going to comply with this rule. Maybe internally they look at how they're having listing agreements signed by by
Right.
clients, and once that listing agreement is signed, we have to wait until a certain time point to advertise it, or whatever the case is. That might be something that brokers have to look at internally a little
Right,
bit.
and you bring up a good point. So you're probably sitting there thinking, well, what about the TR form listing agreement that most
Right.
everybody uses? That's going to have to be changed, and it's in the process of being changed right now. And so I'm guessing between now and May 1, or even sooner, you will see a new listing agreement from TR that adapts or incorporates this issue of the Clear Cooperation rule. So be
Right.
looking for that, and you want to be sure to make that transition from the old form to the new form when it comes out.
Okay, so I don't think we know the answers to this yet, because this is something that the MLS advisory group and the board of directors will be looking at and deciding how that we comply. But a good point here Andy brought up is, will we make incomplete listings searchable? So that's something that the MLS group could
Right.
look into, if that's an option. So Nora said, I see a lot of off-market listings from investment groups. They typically send it to a specific buyer's list. Would that be a violation, since those buyers are not realtors?
Well, if they're this begins with you MLS members, and then B, if it's a broker and they're sending it to their own clients, and that's, like I said, that's a term that hasn't really been defined. That is, quote, clients.
Mm-hmm.
Then, and it's off MLS, and that's presumably okay under NAR. But if you start sending information about a listing beyond your clients and to the broader market, and it's not in the MLS, then
Mm-hmm.
you probably are public advertising and will need to put it in the MLS within one business day of making that move. And bear in mind, just something to think about. I mean, whenever all the process internally at HAR is done and the rule is in there, and there's going to be penalties and sanctions, I'm guessing,
Mm-hmm.
for not following this rule. So that's something to think about also as the rule comes out, and as you get adjustment to the rule, to the extent it even affects you. Like I said, I think most brokers, most listings, most members, it's business as usual, because your mindset is typically to get this property out to as many eyes
Sure.
as possible, because you want it sold for your seller.
Yeah, absolutely.
So.
That last comment you were making about how it's going to be policed, Summer was actually asking the same thing. How are the MLS and the board going to police this? And that's actually what they're looking at right now.
That's what they're looking at right now. But I mean, we have rules. You have rules right now, and so the policing will be the same as they are.
Business as usual.
Yeah, it's
like
current
it is
rules.
now,
I mean,
yeah.
so I mean, there's fines and so forth being handed out as we speak on a daily basis, or warnings or whatever process we have in place, and so that process we have in place will continue to be applied to this rule.
Yeah, very good. Okay, a lot of great conversation in here about this, so happy to see our members talking about it and interested in this. Moving away from that for just a little bit, in 2018, Trek updated their advertising rules.
Right.
This is something that was very confusing for our members at the time, it seems, and even to this day, I get a lot of questions about advertising. Can you maybe share that a little bit with us and help our members understand how they can keep their ads in compliance?
Well, I think, believe me, it would have been real confusing had Trek gotten the rules that they wanted to put in place, and we, being HAR, along with TAR, led the fight to actually make it as simplified as possible and more streamlined and more, hopefully, easier for members, licensees to follow, because what was being proposed was way out of bounds. And so ultimately the rule that got in place was presumably more simplified, and it really is, because it's basically saying that as you as a licensee, if you're going to advertise your brokerage services to the public, then not only, obviously, you might have your name and contact information, but you also have to have your broker's name as part of that advertisement. And the broker's name doesn't even have to be at the same level as your name. I think it's at half the size or something visible. And I think the rule literally has it reads, says half the size of whatever size is the licensee's name and information. So the point is, all of you who are licensees or under the umbrella of a broker, whether you're an associate broker, a licensed agent, or whatever, you're sponsored by a broker. And so if you're advertising, you need to make sure that broker who sponsors you is part of the advertisement. And the reason why, it gets back to, is because under the law, the broker is responsible for your conduct, and so, or can be responsible, depending on the circumstances. And so if somebody sees, if there's something being done that's wrong, the consumer, and this is what this is all about, the consumer can not only see you and your contact information, but if they want to contact your broker, they can also see that information and then make the connection and contact your broker, or whatever the situation may be, that they may have an issue or may not have an issue. Maybe they want to contact your broker to give you a compliment. I don't know, but it's...
Trek's goal really is just to make it clear,
right.
going back to that word, for
right.
consumers, that
right.
it doesn't end with the realtor.
Right,
that they
and so, it's just trying to be transparent as possible.
Right.
And I think the rule that's in place right now is pretty transparent.
Right.
Essentially, just in your mind, your broker's name has got to be on your advertisement.
Okay.
However means you advertise, just remember your broker's name's got to be on there too.
And that's I guess where I think some of the questions come into play, because they say advertisements and they say websites, but Trek has a very clear definition of what constitutes a website as well.
Right.
And it's not just the HAR agent website or the company website you have. They consider anything that you're using to drive business a website.
Right. It gets back to the fundamental term, advertisement. And so that is not a term that's foreign to any of us, or should not be. So any sort of expressive manner through whatever vehicle, promoting yourself or promoting a property needs to be in compliance with the rule. And the rule is have your broker as a part of that. Let's face it, the broker has the listing to begin with. That's who's at that moment in time, that's where the listing sits.
Right. So I have a question for you, because I want to make this as simple as possible for our members. Is a Facebook page considered a website?
Well, a Facebook page is considered advertisement.
Yeah.
And so it equally or likewise is under the application of the rules.
Okay. Can I tell you something a little scary?
Okay, sure. It's not October, but I can be scared. Sure.
Okay. So obviously, my title, social media manager. I'm on social media a lot. I see so many realtors with no broker information on their social media platforms like Facebook.
Right.
Some, even worse, have the wrong broker listed on there. So that would not be in compliance, correct?
That's true.
Okay.
Yeah. I mean, just like I said, it's never mind where you're doing your advertisement. If it's advertisement, it's got to have the broker involved.
Okay.
You know, and it makes sense in the sense of that's who is your sponsor, and that's who the listing agreement technically is with. And so even if you're advertising and it's not a property, so I mean, don't make the mistake, oh well, I'm not advertising the property, so I don't have to follow the rule. Well, even if you're just simply advertising yourself and what a great broker you are, or
seeking referrals and things like that,
and whatever it is you're doing just personally that maybe doesn't involve a specific property, if it's advertisement, the rule applies, and the rule should not be that difficult to follow.
Okay, very good. And I would say if you have not seen all the information about it, just go Google track advertising rules. There's even a PowerPoint that they have on their website that you can download and view.
TREC has information, TR has information on their website. I mean, there's a lot of FAQs on TR and on TREC, and the rule you can go to, the rule is 535.155 is advertisements, and you can Google that and pop right up, and then using the different names for your team name or assumed name, all that sort of stuff that applies. That's 535.154, and so it's it's fairly easy to sort of find the trail and get to the end and determine how this fits for me. And but at the end of the day, the broker's got to be involved in your advertisement as far as consumers seeing that broker's name.
Okay, very good. Just a couple questions here on this. Summer asked, if the realtor has the wrong broker on their Facebook, does the prior broker get a warning on this as well as the agent?
Well, I probably both. I mean, so, but I would guess, and it's hard to predict how TREC operates, even though that certainty is getting better since things have changed up there. But I think if I'm TREC, I would probably come down on the person who placed the ad up there, and that would be the agent.
Okay.
And if the agent can't get the right broker on their advertisement, the agent needs to learn to get that right, and so that might be TREC's focus. It
should be a priority. Andrew said, so on a Facebook business page, I have the broker's name and address. Am I good?
Yes.
Okay. Easy answer there.
And make sure it's the broker's name, as you mentioned earlier, the one that shows up on the TREC. When you go to the TREC records and you search a name, make sure it's the name that is publicly being used by the broker, and that name is reflected in the TREC records, or should be.
Very good, which actually answers or goes along with Marilinda's question. If you're an independent broker only using your name, does that mean you meet the requirements? Well, it would imagine as long as it's what's listed with TREC.
What's listed with TREC, yes.
Very good. Okay. Nora asked, do I need to put information about brokerage services on Instagram and LinkedIn?
What do we do on that? Don't we? You have a page
TREC's rules.
Yeah, that links back. If you can't get it on the actual page, then there's got to be a link back to it to your information page or
and TREC's rules on that, Nora, specifically list Facebook business pages only.
Right.
They don't list every platform out, but I think our recommendation would be just put it anywhere.
Right. I would think, like I said, I mean, that's information, or that's a something available to the public about you, and so that could be that first contact. And so I think that rule of having that form linked somewhere still applies, even though it's they just mail and use Facebook. It's still sort of the same. It's a very close cousin of the Facebook rule.
And just a suggestion, I have a suggestion back to Andrew. Andrew mentioned specifically his Facebook business page. He has his broker's name and address. If you're using your personal page at all to promote your business, I would have your broker information on there too, right? Because you're also using that to drive business.
Right.
All right.
I think so. I agree.
Okay, very good. Let's talk a little bit about the seller's disclosure. This was updated recently. Can you explain what changed on the seller's disclosure and why?
Well, I think that the biggest changes, and it was led by Senator Joan Huffman from Houston, were the amplification, more information, more questions about flooding, and issues related to Addicks Dam and what happened out there, and just general more information about the flood zones and the different levels of the flood zone. And so, it actually created almost an entire page of questions about that, and so that to me was the changes to the seller disclosure notice were brought about because of Harvey, and so therefore the most material changes are Harvey related type questions, and so I don't think it puts a little bit more burden to be forthright and to answer what's asked, but it's probably information that is helpful, or certainly would be discussed in this day and age, even if it wasn't in the seller disclosure notice.
Right.
So.
All right.
So I mean, I think it's I heard somebody say the other day that some agents are still having trouble recognizing that there's a new form.
Actually, yes, Kelly mentioned if there was a seller disclosure uploaded into the MLS that's outdated, is the listing agent required to have the new form executed and replace the old form? And then she also said, and what can we do if they refuse?
Well, yes, the new form needs to be used, period. Okay, and if you get a old form, and then I think you as the buyer's agent should, in writing, email, phone call, all three, whatever it takes, get a new and updated disclosure form from the seller. And and if you look at the contract, because that could be in violation of the contract, because at paragraph, I think it's, let's see, section 4, in the contract, section 7, B2, I think it is. Well, you know where it is. You got to provide the seller disclosure notice, and if you don't do it in a timely basis per the contract, then the buyer can walk out of the contract somewhere down the road for that very reason. And so, if you're providing a disclosure statement that is incorrect or not up to date, then you're probably not meeting that contract provision.
Okay.
And so,
can they report it like they report MLS violations?
They can contact MLS and let MLS know that seller disclosure notice is outdated. It's not the correct one. So yeah, for sure.
Very good.
Yeah.
Okay. Well, that looks like all the questions that I have for you, and I don't see any others coming in from our members. Do you have anything else you want to share before we wrap up?
Just on the seller disclosure notice, how much time we have?
We're right at time.
Okay. On the seller disclosure notice, I mean, I think this still is an issue, whether new form, old form, is get the thing filled out. Make sure that you as the listing agent, that your client, the seller, fills it out. Then you're not duty bound to make sure it's accurate, but you are, I think, duty bound to make sure it's completed.
Yeah.
And then on the flip side, if you're a buyer's agent, and you get a seller disclosure notice that A is outdated, we already discussed what you do on that. But if you get one that's the current form and it's somewhat incomplete, you need to raise that issue with the seller.
Yeah.
With the listing agent.
Somebody actually brought that up here. I find agents working with investors who flip are not willing to, or excuse me, are not filling out the seller disclosure in full or marking no to all the answers. How do you handle this when the agent or seller refuses to complete?
Well, you perhaps move on to another property.
Yeah.
I mean, that's like red flags everywhere. And so, but if you're a buyer's agent and it's incomplete, you need to get that information completed. If you're a buyer's agent and there's information that seems to suggest there might be an issue, even though the language may not say everything that you want it to say, or it may not be a full paragraph, it may just be a few words or one sentence. Something that you as the expert in the transaction that should alert you that maybe I need to ask more questions on behalf of my buyer. And so that's critical for a buyer's agent to go over it and look for things that might be sensitive to the buyer, because to be honest with you, this is the statement's even longer now, the disclosure notice. We know it's longer than it was in the past. And a buyer, especially a first-time buyer looking at that for the first time, may not be able to comprehend everything that's going on there and really recognize what's being said to them. You as their agent should be able to recognize what is being said and should be sensitive to what your buyer may not want to incur or buy or take on.
Very good. Well, Grant, this has been wonderful. Thank you again for joining us.
Sure. It's great to be here.
Yeah, and our members love you. They have so many comments and questions for you.
It's a love affair.
It certainly is. I just want to remind everyone before we wrap up that today's Member Focus Monday and this week's HAR on the Move podcast are sponsored by Rodox, a telemedicine company you can trust. Also, looking ahead to next Monday, I will be solo on next Monday going over social media security. So we talked a little bit about social media today in regards to advertising compliance. But next week we're going to be talking about all security settings, and I know a lot of people have questions about that. So be sure to tune in next Monday at 9 a.m. Have a great week, everyone.